Hello and welcome to this webinar presented by the New York MGMA in collaboration with the Connecticut, Delaware, Maryland, Massachusetts, Rhode Island, Pennsylvania, and Virginia MGMA. My name is Emily Long and I will be your host. Today's presentation is led by Gina Campanella. Ms. Campanella focuses on healthcare regulatory and transactional matters federally and in New Jersey, New York, and Pennsylvania. Ms. Campanella has assisted clients with transactional services and regulatory compliance consulting, as well as general counsel services to small practices and large societies and medical groups alike. Clients also seek her expertise when reviewing employment agreements, formation of new practices, separation from and sale of practices, business structuring, and surgical center licensing and registration, including preparation for Department of Health, AAAHC, and AAASF surveys of licensed and Medicare-deemed facilities, as well as preparation and implementation of resulting plans of correction. Before we get started, I would like to review a few housekeeping items and let you know how you can partake in today's web event. The viewer window is on the right, and it allows you to see everything the presenter is sharing. The control panel is on the left, and that is how you can participate in the webinar. The audio panel provides audio information. By default, you have joined the webinar using microphone and speakers. If you prefer, you can join the audio using your telephone by selecting Use Telephone under the audio drop-down box. The dial-in information will be displayed, including the audio pin. During the presentation, you have the ability to send questions to our staff through the chat box found on the left side of your screen. Simply type in your question and click Send. At the end of the presentation, we will do a question and answer session. As a final reminder, we are recording today's webinar. You can view a copy of this presentation and recording on the participating MGMA website. Please welcome Gina Campanella with Physicians' Employment Agreements and Contract Negotiation Skills.
Hi, everybody. Good afternoon. Thank you very much for attending today. It is my pleasure to speak with you about physician employment agreements and contract negotiation skills. What I have given this presentation to both physicians who are seeking to be employed, as well as practice managers such as yourselves, and practice owners who are looking to employ individuals. So I will try to keep it a bit neutral, because some of you might also be individuals seeking to enter into employment agreements. So I like to kind of give a view from both sides of the desk. As Emily had said, any questions, I'd be happy to address them at the end. So please make sure you write down any questions you might have as we go, and I'm happy to go back and address them. Again, Emily gave you a very nice background for me. And I am licensed in New York, New Jersey, and Pennsylvania, and I do currently work in all of those states. One of the biggest questions that I get when I am dealing with not only employees, employed physicians, but also employers is, well, are they a W-2 or are they a 1099? And what I generally advise my clients is that's not really something that an employer or an employee can unilaterally decide. That is an analysis we have to go through. It is based upon IRS requirements, and typically things that they look for are as follows. It's a W-2 employment if the document is titled an employment agreement, and if it is an employment agreement, it's going to have things such as paid benefits, paid time off. The employer dictates when the employee works, when the employee does not work, what the employee's schedule is, things of that nature. And then we all know, those of us who have worked and have gotten a W-2, that taxes are taken out by the employer with the employer portion paid. A 1099 employee is not, and I try to be very careful with my clients, don't refer to your 1099s as employees, because what they really are independent contractors. And you really have to make sure when you're entering into these agreements that if you do envision it as a 1099 contractor scenario, there really can't be anything such as paid benefits, paid time off. The independent contractor really needs to have a certain level of control over his or her schedule. Essentially, when they can work, they do. If they can't work, they don't. And quite frankly, if they can work and they work, they get paid. And if they can't work and they don't work, they don't. So that's really where you get into the independent contractor scenario. When you have an independent contractor, you are not removing any taxes from payment. When you're paying the employee is getting their gross payment all at once. And there's no employer portion of comparable taxes paid. Now, this is important on both the employee and the employer side. It's important for the employee to know the way that their taxes are being paid, because the employee will typically need to make affirmative quarterly tax payments because you still have to pay income taxes. I unfortunately have had clients that have not realized they've had to save as much as they thought they did from their 1099 contractor payments, and they got themselves in a bit of a bind when it came time for the end of the tax year. So typically quarterly tax payments do need to be made by the employee. And then what the employer also needs to realize is that the employer is also not paying an employer portion of taxes. And so you really want to make sure that this person that you're paying as a contractor is really a contractor. Because if they are not really a contractor and they leave your employ and then they do something like try to file for unemployment benefits or something like that, they will then go to the government and say, no, I was really an employee. I wasn't really an independent contractor. And then you will, if it is found by the government that they really were an employee and they were not an independent contractor, then you will have to make a bulk payment of any employment taxes that the government feels that should have been paid by the company. Basic terms. Now, these are the terms that when I tell clients, these are the things I need to know that you want. And these are really the same kind of basic terms from both the employer and the employee standpoint. Is it a full-time or a part-time position? What is the work schedule? Are there any requirements to take call or provide sick coverage? This is important from both an employee and an employer standpoint. It's important for the employees because they need to know, what am I going to be required to do when I'm off, when I'm not working, when it's not my day? Am I going to be required if one of my colleagues becomes ill to work in their place? When am I going to be required to take call for patients? It's very important on the employer side because you need to know if one of my docs is ill, if one of my providers is ill. Do I have an ability to call one of my other providers, and do we have a system in place where other providers are on standby to come in and work for that ill physician? What is the term of employment? Term of employment is tricky. I always tell my clients the term of employment is really only as long as your termination without cause provision. We'll talk about termination in a little bit. But if you could have a 2-year contract, you could have a 5-year contract, you could have a 10-year contract. If you have a 60-day notice period to terminate without cause, then at any given point in time, there's really only 60 days of guaranteed employment. Does the term automatically renew? And if so, how does the employee or the employer stop it from renewing if you don't want it to renew? Again, this is a basic term. Typically, there will also be a non-renewable provision in contracts where it says, hey, this is a 1-year contract. It'll automatically renew every year. But if one party or the other doesn't want it to renew, they have to give the other party 90 days, 180 days, 30 days notice that they don't want it to renew. And it's important that both sides have that knowledge and understanding. And I typically advise my clients to mark these dates on their personal calendars, just so they know, just so it's in their forefront of their mind and they know when they're coming up. Professional and administrative duties should provide reasonable detail on both the employer and the employee side. So I have had clients that have said, I just want to tell them that, they're going to have to do clinical duties and then they're also going to have to do administrative duties. I like to provide a little bit more detail on both sides, and here's why. I think if you manage expectations from the beginning, then, everybody knows what the expectations are on both sides, and it's much less of a chance that there's going to be problems once the person starts. I'm a very big proponent of kind of discussing the issues, not hiding anything on either side, and, discussing these things before the person signs on the dotted line and before they come in as an employee, and then you have a much more pleasant employment experience. Again, on-call coverage requirements are very important, and location where duties are performed. We're in a day and age now of supergroups, of multiple offices. Many physicians want to know, for example, in New Jersey, where I'm based, you can have physician practices that have offices in the northeastern corner of New Jersey, as well as offices in the southwestern corner of New Jersey. Anyone who's familiar with New Jersey knows that the northwestern corner of New Jersey is about 3 to 4 hours from the southernmost or southwesternmost corner of New Jersey, depending on time of day and traffic and things like that. So you don't want to end up having a physician be surprised that they might have to travel on occasion to other offices, because that could be a very big consideration for them when accepting the position. So these are things I call it burying the lead. When you're dealing with issues such as this in an employment agreement, you don't want to bury the lead. You want everything to be up front and center, and that's really going to help you get the best, most compliant candidate. Compensation. This is really what many of my clients are most focused on. When we're discussing employment agreements, and quite frankly, I typically have to refocus them on some things that I find to be critical issues. But you want to know, what is the compensation going to be? Obviously, none of us work for fun. We may enjoy our jobs, and we may love what we do, but ultimately, at the end of the day, we're all working to make a living. So what will the compensation be? How will it be determined, and how will it be paid? Is there any allowance for a bonus? And if so, how is that determined, and how will that be paid? Now, you want to be very careful. There are different ways that it is legally permissible to compensate a W-2 employee, that it is not legally permissible to compensate a 1099 contractor. When your practice is entering into an employment agreement, you definitely want to make sure that you work with your healthcare counsel to make sure that you are entering into a legally compliant method of compensation. It's more critical, however, though, when you're entering into a contractor agreement, because like I said, there are many ways that it's perfectly legal to compensate a physician or licensed healthcare provider as a W-2 employee that are not even remotely compliant, regulatorily compliant, if that person is a contractor. These scenarios that are okay as a W-2 employee, once the person goes into the contractor space, they become violations of the Stark and anti-kickback regulations. For anyone who's not familiar with Stark and anti-kickback, at their most basic, Stark and anti-kickback are the set of federal laws and regulations that essentially govern how physicians and healthcare providers can be compensated so as to protect against illegal payments for referrals for services. So when you get into the contractor space, you really want to make sure that you have the proposed compensation scrutinized by competent healthcare counsel to make sure it's compliant. Because when you do have a violation of Stark or anti-kickback, everyone gets in trouble. The payer of the alleged kickback, the recipient of the alleged kickback, and there is no requirement that their payments were intended to be a kickback. So you really have to be very careful that the compensation scenario fits within the necessary guidelines. Are there provisions for annual raises, and are there provisions for downward modification of salary, and is there any allowance for paid time off? Okay. Now here are just some different types of compensation. There's a flat-based salary approach, base salary plus incentive compensation, bonus compensation, based on RVUs, quality-related, patient satisfaction-related, use of EHR-related, dependent upon how well and how timely charts are completed, bonuses for taking extra call, and also additional compensation for supervision of residents or nurses. Flat-based salary, I typically find that the compensation models that work best are some combination of the two, flat-based plus some type of incentive, bonus, RVU, something of that nature. Okay, and I find that from both the employer and the employee standpoint, that typically works very well for two reasons. First and foremost, everybody knows what the flat base is that the physician can expect to receive and that the practice can expect to pay. Then, if somebody wants to work harder, work more, put in more time, effort, things like that, then they can make more. And you can make it as easy or as difficult for someone to earn more as you would like to do. But I find that flat base plus is really one of the best scenarios all around for both employer and employee. And when I work with my clients putting together employment agreements and contractor agreements, I do encourage them to get creative with compensation models, so long as we are compliant with those Stark and anti-kickback regulations I mentioned. Many physicians and employees are going to want to know, is there medical insurance available? If so, how is it paid? When am I eligible? Is there coverage for my dependents? A lot of these things now, post-Affordable Care Act, are strictly dictated by the law and the company with which your practice has contracted to provide these services. One of the problems I'm finding now is that many employees do not understand that some of these, or many of these provisions, such as eligibility, contribution from employee, things of that nature, are not really something that the employer has the authority to change. They are dictated now many times by the insurance provider. So I'm recommending now to my clients who are employers, be upfront with that from the beginning, because you don't want to get to the point where you're negotiating an employment agreement and your potential employee is trying to negotiate these things. Just be upfront from the beginning. Say, hey, we offer medical, we offer dental, we offer coverage, but we are restricted. We have to offer it within the guidelines that our company that provides these benefits for our employees says that we have to provide them within, and here are those guidelines. And then you won't get stuck on something that really can't be changed. Provisions for CME licensure and certification reimbursements. That's also a very popular benefit that many employed physicians are looking for. A lot of, as we know, a lot of our physicians do get to go to wonderful places for CME conferences, and they typically need time off to go to their CME conferences because, they can't be working and doing CME at the same time. So I've seen a lot of different scenarios where, it's one fewer week paid time off than the person probably would have gotten, but then there's an extra week permissible for CME, and the employer will compensate up to a certain amount of travel or expenses or registration fees for that CME. And then retirement plans. A lot of this to me is kind of in the same category as healthcare. I'm seeing more and more that employees they don't really understand, particularly my new physician employees that I work with, that these types of things, it is whatever retirement plan that the employer subscribes to, and typically the terms as to when you can start participating, what the match is, things like that, they're determined by the company that provides the plan. Okay, for professional liability insurance, a lot of my employers that I work with, they'll say, hey, Gina, what do you really recommend here? The malpractice is high. I'm paying a good salary. I would like the employed physician to pay for their own malpractice if I can. So can we just require them to get their malpractice? What I generally recommend is if you are hiring an independent contractor, then yes, it's entirely reasonable that person should have their own malpractice and should be paying for it, because the assumption is if they are an independent contractor, you are not the only person they're working for. They're working maybe 2, 3 other different places. They just like the flexible schedule. They like being a contractor. Perhaps, it's an anesthesiologist that works at a different surgical center every day of the week. But the idea is that this person has set themselves up in such a way that they can be available to be an independent contractor, and they should already have the professional liability insurance in place. So independent contractor, I am perfectly comfortable with that. I typically like to advise my employer clients that are bringing on an employed physician that they should be the ones for getting the malpractice, responsible for getting the malpractice policy. Simply because then you know it's in place, you know what kind of malpractice the person has, because quite frankly, if they get sued, your whole practice is getting sued. And then you know what's there, you know what kind of coverage you have. And then, honestly, the matter of compensation for the premium, to me, that's a bargaining chip, just like compensation, benefits, anything else. Okay, and then a quick word about types of insurance. There are 2 types of professional liability insurance. One is claims made. The other is occurrence-based. And I actually find that many times, I don't like to gloss over this, so if anybody is saying, oh, Gina, this is so basic, why are you wasting our time with this? You'd be surprised how many people actually don't want to admit that they're not really clear what the difference is. Claims made is, and I like to remember that that's the crummy one, they both start with C. Claims made means that the physician is covered for any malpractice that occurred while they were covered by the policy, and the malpractice claim was made while they were covered by the policy. Once you're no longer covered by that malpractice policy, if a claim comes up for a service that was provided while you were covered by that policy, you are not covered unless you purchase what is called extended reporting coverage, or a tail. Tail insurance can be incredibly expensive. So you also want to make sure, if you know that your practice has a claims-made policy, or if your practice is leaving it up to the contractor or the employee to get their own insurance, you want to specify who is responsible for paying for that tail policy should a claims-made policy be purchased. I generally advise everyone, if you could afford occurrence-based, that's really the best practices, is to get occurrence-based. Occurrence-based essentially means that no matter when the claim is made, as long as you were covered by that policy when the underlying event that led to the claim occurred, then you are covered. So you need no extended reporting or tail policy for that type of insurance. Is outside employment permitted? This is also very critical, because you want to know, is your doctor going to be spending time doing outside consulting, speaking at programs? If they are doing that, do you want those fees coming back into your practice and being distributed through the practice, or are they allowed to individually retain those fees, honoraria, and other outside income? Generally, I find that my clients who are employers kind of split this one of 2 ways. If the employed physician is going to be doing outside clinical employment, they want that money to come back to the practice, because the feeling is if you're doing outside clinical employment, then you should be doing more clinical employment for the practice, and it should benefit the whole practice. However, it would be very atypical for a practice to be going after individual physician speaking fees, honoraria, or other outside income, because quite frankly, that just doesn't encourage your employed physicians to engage in these types of activities, and these types of activities are very beneficial to the full practice. Okay, termination. So now we've gotten through, you've brought the employee or the contractor on, everything's great, everything's been going wonderfully, hopefully for years. A lot of one scenario of termination I see a lot is just life change, something like that. Or I've also seen the scenarios where nothing has been going right since day one, nobody's happy, and something needs to give. Okay, you always want to make sure that you address all the possible ways that an agreement can be terminated in the underlying agreement. Is there an option for employee or employer's termination of the agreement? And if so, how do they terminate the agreement? Okay, what are the options for the employer to terminate the agreement? Typically, there are way more options for the employer to terminate agreement. And typically, all of those multiple options are called for-cause events. A for-cause event is essentially the employee does something bad. So the employee can be fired because they did something bad. That is at its most basic. Does the employer have the sole discretion to determine a for-cause event? And is there any provision for the employee to be provided with notice of a problem and have time to cure the problem? There are some scenarios where it's perfectly reasonable to give the employee notice they're doing something wrong and give them a chance to fix it. For example, a violation of a practice policy and procedure. If you have a physician that, let's say, is for some reason, they decide to they're going to dictate all their charts on Friday morning, because Friday mornings are usually slow. But your practice has a policy that all charts have to be dictated within, let's say, 24 hours. That's a reasonable scenario where you say, hey, listen, doctor, you have to dictate all your charts in 24 hours. You can't just save them up and do them once a week on Friday mornings. However, if there's a scenario where the doctor does something that's putting patient safety at risk, that's not a reasonable scenario to give notice and give a chance to cure. Because if there is no cure, it's essentially the practice knew that something was happening that was putting patients in danger and didn't take immediate action to fix it. So you have to be very careful with what you define as a for-cause event for termination as the employer, and you have to be very careful with what you're willing to concede that you're allowing a notice and a cure period for. Okay, professional liability insurance, just circling back to that. I'm sorry. I went out of order. Okay, there we go. My apologies. I was going out of order. I clicked the wrong place. Non-competition. Okay, so you want to, once the person's terminated, then you want to determine, okay, can they compete with us? Is the employee permitted to work for any other employer or have ownership interest in any type of facility or provider during the term of the employment? There's really two pieces to non-competition. You basically want to define what potentially competitive activity is permitted when we are working together, and what potentially competitive activity is permitted when we're no longer working together. Is the employee going to be restricted in practice for any period of time after termination? If so, how far and how long? Generally, how far and how long is incredibly regional. I have clients in Midtown Manhattan where I say, 10 blocks, 10 city blocks for a year is a reasonable restrictive covenant. And then I have clients that are in more suburban areas of New Jersey where 5 miles and maybe 2 years is much more reasonable. So it's incredibly regional. I've actually even done employment agreement reviews for clients of mine that were presently located in New York or New Jersey that were moving to other states. And I'll even say to them, listen, I can do this for you, everything except for the restrictive covenant. And I think you need to consult with someone locally because I don't know what this area of Wisconsin looks like. And they're incredibly regional. But you want to make sure it's reasonable. And I'm actually seeing a very shocking trend in New Jersey of employers demanding increasingly unreasonable restrictive covenants. And it's actually quite frustrating to me because these demands for unreasonable restrictive covenants are actually coming from employers who I know are using other healthcare law firms that I'm familiar with. And I would never advise an employer client to insist on an incredibly unreasonable restrictive covenant in an employment agreement, and here's why. On the other side, many employees will agree to unreasonable restrictive covenants because either they don't really think that they have the ability to be enforced, which in every state except for, I believe it's California, restrictive covenants are very enforceable. They used to not be enforceable in New Jersey, but several years ago, there were some court cases where it came out that they were in fact enforceable. But what the court will do is they will do what's called a blue lining of the restrictive covenant. So if they find that a restrictive covenant is unreasonable, they will reduce it in geographic area and/or time. And then you will have a new restrictive covenant that's smaller, a smaller geographic area and perhaps a shorter period of time that's reasonable. There has to be that perfect balance in a restrictive covenant for it to be protective of the employer's interest, but it also cannot unreasonably prohibit the employee from making a living. So you have, I apologize, I'm so sorry, I'm seeing questions come up in the chat box, but I'm going to address them all at the end. If you have, so yes, so your restrictive covenants are legally enforceable in almost every state. If you are in a specific state where you think they are not enforceable and you would like me to double check, please, I encourage you to email me after this lecture today, and I would be happy to double check that for you. But the reason why, even from an employer's standpoint, you don't want to really insist on incredibly unreasonable restrictive covenants is because it is more likely than not that there is going to come a time when that employee leaves your practice. That employee is going to want to work elsewhere. And unless the two of you can agree at the time they leave, when chances are you do not have a good relationship anymore, you're not communicating well anymore, there's a reason why people leave, okay? Unless you can agree at that point, yes, okay, fine, you can work at, XYZ practice that's only 11 miles away, even though your restrictive covenant is 15 miles. Unless you can agree at that point, your practice is going to end up involved in litigation about how reasonable your restrictive covenant is. And I don't find it to be good practice to have incredibly unreasonable restrictive covenants that are an invitation for litigation in employment agreements from the employer side. I would much prefer to advise my employer clients to have reasonable restrictive covenants that no one's going to go to another attorney after they leave and have that attorney say, yeah, this is unreasonable, let's litigate. Because you're just going to end up costing yourselves money later. Okay, just some additional considerations, all right? Is the employer going to pay license and registration fees, medical society and special society dues, any kind of moving and relocation expenses, any kind of student loan repayment? We've kind of touched on CME already a little bit, or travel and automobile allowance. License and registration fees, sometimes they're covered, sometimes they're not. It's really just generally what the practice does. Medical society and special society dues, same thing. I find that if the practice, just by business practice covers them, they do. If they don't, they don't. Sometimes they might say, well, we'll cover one a year. You pick which one and you tell us. Or sometimes they might say, well, we're only going to cover one a year and it's the one we want you to belong to. So let's say, we just by way of example, we want everyone to belong to the American Medical Association, so we will pay your annual American Medical Association dues. And then same thing with license and registration fees. If it's a practice in New Jersey, they might say, okay, well, we'll pay your annual licensing renewal fees for New Jersey. But hey, Doc, you're also licensed in New York, you're also licensed in Pennsylvania, you're also licensed in Florida. We're not paying for all of those because we only need you to be licensed in New Jersey. Okay. So now as far as moving and relocation expenses and student loan repayment, what I always advise my employer clients is that these things, they can be covered. But what you want to do is you want to make them repayable on a certain prorated basis, because you don't want somebody taking your relocation bonus or student loan repayments or something like that, moving themselves back to your state, and then deciding in 3 months that they're not happy and leaving the position, and then you essentially paid for someone to come to your state, and you have no recourse under the contract. I actually had an experience similar to this with a client about 4 years ago. My client was the employer practice, and the practice had actually sponsored the physician's visa to come to the United States at great expense, both legal expense, application fees, all sorts of fees. And as soon as the physician got to the United States, they immediately started looking for a new job, because it was much easier and less expensive to sponsor someone who's already here on that type of a visa than it is to actually bring them here. So they left within a matter of 3 months, and my clients had no recourse to go after this person for reimbursement of any of the expenses, because to be honest, they had used an old form of employment agreement that I had drafted for them in the past that was not for an employee that was coming over on a visa, and they thought that, they could just erase the names and the addresses, and they did not come back to me to address any of the visa issues. So they were essentially just out that money. Okay, there is a significant trend with physician and hospital employment agreements. A survey by the National Medical Group Management Association shows that there's nearly a 75% increase in the number of doctors employed by hospitals. I'm not sure how many of you on the line today are actually hospital-based practice managers, but that is significantly increasing as well. And recent surveys of hospital leaders also show that hospitals intend to continue increasing physician employment. Okay, why do hospitals want to employ physicians? Hospitals want to employ physicians because there's increased competition for physician services. Revenue from outpatient services can then be brought back into the hospital. The hospitals really want to increase their market share. You have a lot more scenarios now where patients can receive wonderful care in many different environments. They don't necessarily have to go to the hospital. So you really have a lot of various different scenarios. And there's also a very high demand for primary care physicians. And then if the hospital is employing the physicians, you don't have a lot of the issues about referrals that you may have in a different kind of scenario. Okay. Why do hospitals want to employ physicians? Continued. Under healthcare reform, pay-for-performance programs were adopted. Reimbursement is increasingly based on quality outcomes, efficiency members, things like development of medical home, use of IT, and general patient satisfaction. And as we all very likely know, patient satisfaction is generally higher when there's continuity of care, and they feel like they can get everything they need in the same basic place. Reimbursement has been increasingly based on quality, coordination of care with physicians, and how better to coordinate care with physicians than to have everybody essentially operating under the same umbrella. Okay, there are, as we all also know, being in the realm of practice management, there are many factors leading to a decline in private practice. Management of private practice is increasingly difficult and costly. Practice managers such as yourselves are increasingly necessary and increasingly in demand. You no longer really have the scenario where the doctor can manage the practice and provide all the clinical care in the practice. Managed care hassles, there's really lack of leverage for these small and solo providers with managed care contractors. Declining reimbursements, which goes a little bit towards managed care hassles. Medical technology and EHR systems are expensive, when we saw EHRs really being implemented across the board several years ago. I also saw a significant increase in the number of solo physicians that were calling me to review agreements to sell their practices to hospitals. Workload and patient coverage. We are increasingly in a society of 24/7 access, 24/7 needs, and demand for 24/7 care. It's very difficult to do that as a solo. And unfortunately, there are certain board requirements in various states that do require that physicians are able to cover their patients' emergent needs on a 24/7 basis. And then essentially employment security and lifestyle. Our lifestyles now are much different than those of our parents were. Many of us are no longer in a single income household. Many of us, both of ourselves and our spouses have to work, or we don't have a spouse. But we're just in a much different lifestyle. And when you're no longer in a single income household, maybe 2 or even 3 income household, depending on if you have adult children in the household, there are more pressing needs for a balance of work and life, because you don't have that person 24/7 taking care of things at home so the breadwinner can be working longer hours. Okay, so basically these are, and I see a lot of questions popping up in the box, so I'm going to kind of roll it up now so we have time to address all of your questions. But my big conclusions when I give these types of presentations, or sometimes I'll go into residency programs and I'll do employment agreement workshops, do not underestimate the value of the written employment agreement. A lot of people, I find it very upsetting, but I have a lot of clients come to me after the fact, and they say, well, I just signed it when I started working because this was my job and I accepted it, and they told me everybody else signed it. It is very valuable to have a written employment agreement, but there's also a significant value to knowing what that agreement means and understanding it before it's entered into. What I actually tell my clients who are employers, have an employee handbook, have comprehensive employer policies, procedures, rules, and regulations. Incorporate these into your employment agreements by reference. That gives the employer more flexibility. You can essentially say, the employee has to follow all of the practice rules, procedures, regulations, and they are incorporated by reference. And then that gives you more flexibility because you can change a policy or a procedure or a rule at any time without having to re-sign an amendment to an employment agreement. And then I actually see some questions popping up. Where do I find a template written employment agreement? I very strongly advise against that. And I wish all of you knew me better to know, but I have actually stood in front of groups and said, you do not need to hire me to do this. Here's where the template is. That's typically when I'm giving my end-of-life care presentation. I tell everybody, I said, you do not need to pay an attorney to execute an advance directive or something of that nature. I highly recommend that you retain an attorney experienced and specializing in healthcare to put together an employment agreement for your practice to be used with your physicians, because it's the templates. This is really not something that's one size fits all. It's not something that works the same in different states. You would need something different for a W-2 that you would need for a 1099, something different for part-time, something different for full-time. Now, that is not to say that you cannot retain an experienced healthcare attorney and say, I want a template employment agreement for my practice. I have done that for my clients. And I have said, okay, use this. If you're changing anything other than name or address or anything like that, if you're changing any substantive terms, call me, let's go through it together. Otherwise, here's your template, enjoy it. Go hire all the doctors you want to hire with it. But I don't think this is something that should be shared among practices or downloaded from a society page or anything like that and just simply used. There are too many moving parts. There's too many different factors. And I've had too many clients come to me that have used a template they got from somewhere else in this specific scenario, and it's ended up being incredibly problematic for them. So now we have about 15 minutes left. So I definitely, I don't know, Emily, will you go back and address the questions for me, or should I be scrolling up in the chat box?
Hi, Gina. I can find where our questions begin for today.
Okay.
And I think from there you'll know what you've answered throughout the presentation.
Okay, excellent. And then please, if anyone has any additional questions, please feel free to ask. I had told Emily at the start, this is generally a presentation that does generate a lot of very good questions.
Okay, so we have where it starts. It says, bearing the lead, some candidates inquire about an in-depth schedule before they sign. Thoughts welcome from presenter.
Okay, so I think some candidates do require about an in-depth schedule. I am never opposed to putting an in-depth schedule in the employment agreement if that is what's going to make the candidate more comfortable. But what I do caution is for my employer clients, I do say somewhere in that agreement, reserve the right to change the schedule. Because things happen, things change, and you don't want an employee terminating the agreement for cause because, you know, they were only supposed to have to work until noon on Saturdays, and now they have to work until 1 on Saturdays. So you really don't want to get into that type of scenario where it's a specific schedule and it cannot be changed. But I've had employment agreements that I've drafted for clients that have been anywhere from, you know, physician's schedule shall be mutually agreed to by the physician and the practice to physician and practice, here's the schedule, but it can be changed within reason by the practice. Or it can be changed, you know, on 30 days notice by mutual agreement of practice and employee. So there's many different ways you can do that, but no, just at its most basic, I am not opposed to detailing schedule in the employment agreement.
Okay.
Go ahead.
Okay, our next question says, if a physician is an independent contractor for an extended period of time and is functioning as a full-time physician, is there a way to offer health benefits at the physician's expense? I'm in Pennsylvania.
Okay. If they are an independent contractor and they're functioning as a full-time physician for an extended period, and they're at the point where you want to offer them health benefits, the real issue there to me is that they probably should be a W-2 employee. If they're working for you full-time, they have a set schedule, and you're in a position where you want to offer them benefits, and that's not a state-to-state thing. That's an IRS thing. I would encourage you to have that scenario reviewed, and if you wanted to email me or give me a call, I am licensed in Pennsylvania. And see if perhaps it's time to switch that position to a W-2 agreement. And that's how you would offer them benefits. I would caution against offering them benefits if they are going to stay as a 1099, because it sounds to me, just from the bits and pieces I know, that they probably already should be a W-2.
Okay, and our next question kind of leads into that. It says, is it unheard of to change an employee W-2 to 1099? I do not believe this employee should have been a W-2 ever. Can that cause issues? If I change them, what should I do to ensure no issues?
Okay. Again, this is one of those scenarios where I say it absolutely cannot, or absolutely rather can be done. It's done all the time. I actually was just retained by a practice 2 days ago to convert 3 1099s to W-2s. Now that the practice is getting more busy and everybody is really able to sustain a full-time schedule from the practice. So to answer your first question, yes, it absolutely can be done. To answer your second question, or the second part of your question, I think it must be done very carefully, and this is one of the scenarios where I do suggest that you retain the healthcare counsel to help you make that transition, just to make sure that it's done properly, all the I's are dotted, all the T's are crossed, and there are no potential problems that can come back and get you on the back end.
Our next question says, I thought things changed / Stark can't cover moving relocation expenses. Is that true?
No. Well, there's really two parts. I would not recommend that relocation or moving expenses be covered if you are hiring a contractor. But for a W-2 employee, there is absolutely no reason that that's not permissible, so long as it's structured properly.
Okay. Our next question is about template structure for Maryland consultant agreements that offer consultancy services for department. It says ongoing thoughts are welcome.
Okay, so I think I'm assuming that question is really going to contractor agreements for Maryland.
Okay, so specifically international consultants providing consultancy services in their capacity as MDs, not providing clinical services.
For department. Okay, so, all right, so then I'm assuming that what you have is you have some type of a practice that uses international physicians to consult but does not provide direct clinical care. That is you're probably getting more into the areas now of telemedicine, I would think. I would have those. Unfortunately, I do not practice in Maryland. That's not one of my states yet. But I would consult with healthcare counsel in your state and just make sure that those agreements are structured properly. But it sounds to me like that's definitely, typically consulting agreements are very squarely in the contractor realm and not in W-2 employee.
Our next question asks, any thoughts on including compensation limitation language for not-for-profit entities?
Compensation limitation language. Unfortunately, that's definitely a multi-layered question, which unfortunately I'm going to have to leave it at it would depend. It's going to depend who the nonprofit is, who they get their funding from. Whomever asked that question, you're more than welcome to email me after the presentation with some more details, and we can help get to the bottom of that for you. But at its most basic, nonprofits kind of have a whole different set of rules that you have to look at.
Okay, our next question, where can you find a templated written employment agreement?
That one I actually had answered. I had seen that one when we started the Q&A, so that one we could go over.
All right, and now we have a question. This is in regards to Virginia. If the contract specifies a 60-day notice of termination by either party, but state law says we are an at-will state, which takes precedence?
Okay. You are an at-will state. New Jersey's an at-will state as well, which essentially means, for those that are unfamiliar with at-will provisions or laws, essentially you work at will. You work at the pleasure of the employer. The employer can essentially terminate you at any time. One doesn't necessarily trump the other, but what the employment agreement with, let's say, a 60-day notice period does is it gives monetary protection. So, for example, you can have an employment agreement. You can have a 60-day notice of termination without clause provision. You, as the employer, essentially just decides, you know what, I can't stand this person anymore. You're fired. You could still potentially owe that person compensation for the 60-day notice period. So that's really what the crux of those notice periods are. It's protection for compensation for that period for the employee. And then also on the flip side, it's protection for the employer that if the employee says, you know what, this is an at-will state, I'm out of here, I quit, which generally, that really is a poor example because that will generally protect the employer. But anyway, just go with me. If the person says, I quit, I'm not giving you my notice, then the practice could potentially go after that person for damages. They can say, well, I had a full slate of patients for the next 60 days, and now I can't see half of them. So I'm going to sue you for damages. You can't force the person to work, but you can sue them for damages. So that's really, the contract really gives everybody an extra level of protection in spite of the fact that it's an at-will state, but it doesn't necessarily negate the fact that we're in an at-will state. I hope that made sense. But I welcome anybody who wants to follow up to email me after the presentation.
Okay. And to go along with that, again, they asked for the state of Virginia, do they have a strong non-compete enforcement?
You know what? I don't practice in Virginia, so I'm not familiar, unfortunately, with whether or not they have strong enforcement of non-competes.
Okay. Our next question, it asks, is it common that a hospital going to take a practice over states, one, if your practice seeks professional help to review the physician-employee contracts they are offering, and to help your group negotiate? We will walk away from the talks. That's,
no.
You look at that one, but okay.
Yeah, I'm actually looking at this one now, and I think if I'm understanding the question properly, it's basically if a hospital is approaching you to purchase your practice, and they say to you, if you get an attorney to review the contracts and help your group negotiate, we walk. We're not going to buy your practice. Don't even talk to them anymore, because first of all, that's, to me, that's almost an egregious ethical violation. It would almost be an egregious ethical violation, quite frankly, by their counsel to say to a potential practice, don't get an attorney or else we're not going to talk to you. I would be very shocked if anyone ever said that. Most of the agreements that I draft actually have provisions in there where everyone acknowledges that they had ability to get their own counsel. And I guarantee you that if a hospital actually said this to you, they have such provisions in their agreement. So it's incredibly uncommon. I have, quite frankly, never had a hospital in New York or New Jersey where I've represented practices being purchased by the hospitals say that. Quite frankly, most of the hospital counsel I deal with, I know them quite well because they're actually excited when the practices get counsel because it makes the transaction easier. So if you're engaging with a hospital that's putting that type of an ultimatum on the table, that's not a good sign. There's plenty of other hospitals.
And our last question here says, does short-term disability insurance apply to a physician in the same way it would to any other employee?
I am assuming for that you're talking about short-term disability insurance. I'm assuming you mean like federal and state protections for short-term disability insurance? Yes. Okay. Yeah. The federal and state laws that provide for things such as family leave, medical leave, short-term disability, those all do apply to physician employees the same way that they would apply to any other employee. Absolutely. And then I can actually see the last one here from Kathy. Notice period of termination most often seen, we use 90 days. I have seen anything from 30 days to 180 days. And I don't think that there's any that's better or worse. I typically will leave that up to my practice's discretion, and here's why. Because it's really up to the practice how long they need to replace a physician. So if it's a practice that feels that they can replace a physician in a month, and they'd rather just have it be a short notice period and get them out and we can replace them or even cover for them or get locums or whatever, and we prefer a shorter notice period, that's great. If it's a very highly specialized practice, let's say I've worked with practices that actually recruit from all over the country, and they say, no, it's going to take me at least 6 months to recruit someone and get them moved to my state to join my practice, then we go with 180 days. But that's really, there's no good or bad. There's no better or worse. That, to me, is something that's entirely dictated by the practice's needs and how long it would take the practice to replace that person. Oh, my goodness. Okay. I guess, well, I think that we would, this is a nice one to close with. What are some unusual perks you've seen other clients offer in order to attract a physician to the practice and help with retention? Some of the unusual perks, and again, you have to make sure that all of these things are set up in a way that they're compliant with IRS guidelines, they're compliant with Stark and anti-kickback. But that said, I have seen practices offer things, and it's particularly in New Jersey, which is a very high cost of living state. I've seen practices offer things such as automobile allowance, travel stipends for commuting, housing stipends. I've actually seen housing stipends be offered. Just generally, you can generally get very creative, but if you're going to get creative, make sure you have competent healthcare counsel helping you be creative, so you don't end up with what my business partner and I call the 3 hots and a cot retirement plan, meaning 3 hots and a cot in federal prison for Stark and anti-kickback violations. And I think that's it.
Thank you, Gina. Do you have anything else you'd like to add before I conclude?
No, that's all. Thank you very much. Like I said, I really appreciate everybody attending today. And if anybody has any questions they think of later or anything they didn't want to ask in front of the group, I encourage emails, and I'm happy to answer any questions you might have.
Thank you.
Thank you very much.
I'd like to thank everyone for attending today's webinar. The recording will be distributed to all registrants through email. If you attended today's webinar as a non-member, please inquire about membership opportunities through your local MGMA chapter. At the conclusion of this webinar, you will be sent a brief survey that will ask you to rate the webinar on a 5-star scale. A separate survey will be sent to your email for a more in-depth look at today's program. That concludes our webinar. Thank you again for attending, and have a great afternoon.